The issue before the Honorable Supreme Court is whether a relief under Section 406 of CRPC is barred due to obstante clause of NI Act under Section 142. Case title of this case is as below: Supreme Court of India Criminal Original Jurisdiction Transfer Petition Criminal number 526527 of 2022. Party to the case, Yogesh is the petitioner and Atlanta Limited is the respondent in this case. Brief history of the case. Six complaint cases were filed against the petitioner by Atlanta Limited respondent herein under Section 138 and 142 of the NI Act 1881. The checks were issued by the petitioner in connection with the purchase of Nava Bay crusher plant from respondent company for a sum of rupees as mentioned and dated wide agreement dated 462019. Deal sale consideration was to be paid in 7 installments. First check issued by the petitioners for a sum of rupees 11 lakh was duly honored upon presentation, but remaining checks dishonored on the strength of the stop payment instructions. First two checks were presented by the respondent company at its bank at Nagpur, which is in Maharashtra, and the remaining four checks at its bank at New Delhi, which were dishonored, and accordingly complaints were filed at respective stations of presentation. That is, two complaints were filed at Nagpur and another one were filed at New Delhi. Issue before the Honorable Court in this case is, by way of these petitions filed under Section 406 CRPC, the petitioners want and request the court that cases filed at Nagpur be transferred to Southwest District Court, Dwarka, New Delhi. Petitioners' counsel contended that all checks belong to the same transaction and it would be proper to be decided together by same court. Whereas counsel for the respondent would say that Section 142 of NAI Act would override the Section 406 CRPC due to non-obstante clause. Case law stated before the Supreme Court in this petition. First one was K. Vaskar versus Balan and others, 1999 7 SCC 510. In this case, the Honorable Court was delighted to observe that this section 138 is complete when all its five components are completed. And the case will be decided by that court where these five components are completed. But where five components of offense are completed and have different areas, then any one of the area in which one of the component is completed will have jurisdiction. Second one was Dasrath Roop Singh Rathore versus State of Maharashtra and another of 2014, Volume 9, SCC 129. In this case, three judges bench observed that a return of check by the dry bank would alone constitute commission of the offence. The place of dry bank will decide place of jurisdiction and not the place of complainant bank. And third case quoted was in A. Premnand versus Escorts Finance Limited and others 2004, Volume 13, SCC 527. Held that all complaints arising out of single transaction to be tried in one court. The relief provided in this case is that the transfer petition was allowed and it was directed that all the cases relating to same transaction will be tried at Dwarka Court, New Delhi. Friends, I have only detailed briefing of the judgment, but if you want the full judgment, The case title I have mentioned in this my video. You can go through the complete judgment. Thank you for watching. See you again.